in line with the theme of language and in line with the discrepancy between the inner ontological reality that records and documents our lived experiences and the need to channel and express that through tongue in clear code that facilitates the syntax, ultimately providing the lines that fill the forms that we submit in this field. I'd like to read this next poem called Translation for Mama by Richard Blanco, 1968, and Pamela Guerrero from the Advocates will be facilitating to make sure that that tongue is enunciated and pronounced in all earnest and in all clarity and origin. What I've written for you, I have always written in English, my language of silent vowel endings, never translated into your language of silent H's.
Lo que he escrito para ti, siempre lo he escrito en inglés, en mi lengua llena de vocales mudas, nunca traducidas a tu idioma de haces mudas.
I've transcribed all your old letters into poems that reconcile your exile from Cuba, but always in English. I've given you back the Guajiro roads you left behind, stretched them into sentences, punctuated with poems, but only in English.
He transcrito todas tus cartas viejas en poemas que reconcilian tu exilio de Cuba, pero siempre en inglés. Te he devuelto los caminos guajiros que dejaste atrás, transformados en oraciones, puntadas por palmas, pero no solamente en inglés.
Thank you. Please assist us in welcoming session 2 and our panelists.
Hi, good morning, everyone. Thank you for being here. And thank you to Pamela and Mahmoud for that introductory poem. My name is Seiko Shastri. I'm the Immigration Litigation Fellow for the Federal Immigration Litigation Clinic here at the law school, and I'm very excited to help present Session 2, Insights from Hindsight, Practical Guidance for Asylum Case Preparation. So in this session, we'll be covering sort of three main topics. Our panelists will be covering in-depth guidance on how to create the strongest case for each element of asylum eligibility, how to avoid common pitfalls when representing asylum seekers in removal proceedings, especially regarding evidence collection and brief writing, and last but not least, how to litigate your client's case before the agency to put them in the best position to continue litigating their case on appeal should the immigration court or the Board of Immigration Appeals deny their asylum claim. So I'll turn it over to our wonderful panelists now. If you could please introduce yourselves and tell us all a little bit about your work.
Hi, everyone. I'm Zach Albin. I'm the staff attorney with the Advocates for Human Rights. I work in the Afghan Legal Clinic project. So the bulk of my job is assisting pro bono attorneys who are representing Afghans who were evacuated here through 2021. Not everyone knows this, but the folks who were evacuated here got 2 years of parole status that's going to expire in 2023. And so we're helping people with mostly many asylum applications and then also special immigrant visas in some cases. Prior to joining the Advocates, I was the Clinical Teaching and Advocacy Fellow at Harvard Law School's Immigration and Refugee Clinical Program. So I was supervising students and teaching classes and working on cases. Our docket was largely Central American asylum, mostly defensive, although we did do affirmative cases as well. At the clinic, in addition to my previous work at a firm in New York City, I have done a number of PFRs, petitions for review at the circuit courts, mostly but not entirely relating to particular social group cognizability, everyone's favorite subject in asylum law. And I got my start in the area right here in the Federal Immigration and Litigation Clinic, class of 2016 at the U, and I worked with Mark Fry, an attorney in St. Paul, for those of you who know him.
Good morning, everyone. My name is Nadia Anguiano Weed, and I am a faculty member at the Binger Center for New Americans here at the law school. And I have the privilege of directing the clinic that Zach graduated from, many of us graduated from, the Federal Immigration Litigation Clinic, that, as the name might suggest, is focused primarily on litigating cases at the federal courts. So we have particularly heavy dockets in habeas litigation, so challenging unlawful immigration detention of non-citizens, particularly in Minnesota, but extended to other places in the U.S. as well. And then we also continue challenging removal orders in the circuit courts and the Supreme Court through what Zach mentioned, petitions for review and other litigation. I also teach in the area of post-conviction relief. Many of our clients are usually in removal proceedings because of contact with the criminal legal system, and we have found that oftentimes the potential only avenue they may have to challenging a removal order is by challenging the conviction itself.
And my name is Mackenzie Heinrichs. I am a fellow and visiting assistant clinical professor at the Immigration and Human Rights Clinic. And our clinic mostly works with asylum seekers and victims of trafficking. We do affirmative and defensive asylum. I also am a 2018 graduate of the University of Minnesota Law School, and I was a student and student director at the Detainee Rights Clinic. After graduating from law school, I did a 2-year clerkship at an immigration court in Otay Mesa, which is right on the border between Tijuana and San Diego. And I also did an Equal Justice Works Fellowship focusing kind of on DACA and undocumented youth in Minnesota at the Immigrant Law Center of Minnesota. Thank you.
Thank you so much, everyone. Okay, so I'll turn it over to Zach to get us started on the elements of asylum.
Sure. So, thank you, Seiko. So the most important thing, if you're working on an asylum case, from my perspective, for the affirmative office or even in removal proceedings, is to make sure you have a clear grasp on each of the elements of asylum. There are, 5 of them. Oops. Oh, but before we get there, I do want to provide a disclaimer, which is, if you go right now to the Code of Federal Regulations website that the federal government puts on, or you look at the asylum regulations, which is 8 CFR 208 for DHS and 8 CFR 1208 for DOJ, the point is you will get a ton of incorrect information. At the end of the previous presidential administration, they published regulations that would have decimated asylum, completely changing the law on nexus, massively expanding the scope of what's considered a frivolous application, allowing judges to pretermit asylum cases without a hearing for the first time. All of this parade of horribles, but none of this was ever put into effect because there were these regulations were enjoined in January 2021 in a case called Pangea v. DHS. So if you're consulting the regulations, if you're citing the regulations in a brief, but even consulting the regulations to figure out, the best framing for your case, it's really important to look to the January 1st, 2020 annualized version of the asylum regulations. Don't cite to any subsequent editions because that could have confused adjudicators. I know for sure that the immigration court and the asylum officers have received training on this, but you want to make sure that citation is very clear in case your case is ending up in federal court, years from now, and who knows what's going to happen with the regulations in the meantime. So keeping that on the record clearly is very important. So the next piece is the elements of the asylum or refugee definition. And you need all of them. Sometimes when we go on what I call immigration lawyer Facebook, you'll see questions that say things like, well, what PSGs are working from El Salvador, right? And that's not a helpful question for a number of reasons. The first of which is you may have a cognizable social group, but that doesn't matter if you can't prove your client has a well-founded fear of persecution on account of that membership. For example, gay men in Canada is probably a cognizable social group. It's immutable, it's particular, and it's socially distinct. But you're going to have a hard time, I think, proving a well-founded fear of persecution on account of that social group, right? So to zoom out, you need all 5 elements of the refugee definition to make out a case for asylum. These elements were set in a treaty system created by the 1951 Refugee Convention and 67 Protocol that the U.S. signed onto and then passed into domestic law with the Refugee Act of 1980. So there is a body of international law that is directly relevant to refugee adjudications in the United States. Perhaps we'll talk a little bit more about that later. But just to recite, the elements for who qualifies for asylum is that someone must have suffered past persecution or have a well-founded fear of future persecution, and well-founded fear, the Supreme Court has told us, is something like a 10% chance of future persecution. What does that word persecution mean? Well, it's ambiguous, right? There's no fixed definition in statute, regulation, or case law on what constitutes persecution, but one way of thinking about it that's anchored in that international body of case law as well as by administrative decisions is to say persecution is the infliction of serious harm plus an element of a failure of state protection. And what that means is that the agent of persecution must either be the state itself or a non-state actor that the state was unwilling or unable to control. The next element, one of the most, well, they're all important, right? Because you need all of them to meet the definition, but one of the trickiest that practitioners run into is the nexus standard. This is the causality standard for who is eligible for asylum, right? And the INA says that nexus is satisfied where at least one central reason for the persecution was a protected ground. Okay, so there can be multiple reasons for persecution. It can be a combination. Maybe it's the protected ground. Maybe there are motives that exist alongside each other, right? So there's some personal dispute between your client and their persecutor, but another central reason their persecutor was going after them was, a protected ground, their religious beliefs, their ethnicity, something like that. Or, the central ground, the protected ground might be intertwined with other reasons potentially for persecution. That's something we see a lot in gender-based cases, for example, right? Where membership in a social group defined gender per se or some other group defined by gender is a reason why often a woman is being targeted for violence that's intertwined with or exists alongside non-protected reasons. But then, to looking at those grounds, I think it's important to emphasize that there are 5 of them. Right? PSG is not the end-all be-all of asylum law. You actually don't have to pick just one, although it's important to understand what is your strongest basis for your claim when you're arguing for it. But if someone has past persecution on account of their race, religion, nationality, or political opinion, right? It doesn't matter whether they can make out an argument of why membership in a particular social group is cognizable, because the protected ground need only be at least one central reason. So to take the example of, the cases we're seeing with Afghan evacuees, for a lot of people, religious beliefs are the strongest basis for showing, past persecution or well-founded fear of future persecution. A lot of the folks who are here have religious beliefs. It could be identities, but it also could be practices, right? The idea that women should be able to go to the mosque, just practicing their religion in a way that is different and will put them at risk by persecution by the Taliban, is a valid basis for establishing a well-founded fear of persecution. Likewise with political opinion, right? A lot of folks who are here are opposed to the Taliban's vision or were activists in some way, either through their work or perhaps through military participation, supporting the former government. And this is true, in contexts outside of Afghanistan as well, right? Folks' beliefs about, the role of women in society, for example, might be a reason they're being targeted for persecution. And that can be a protected political opinion. So it's important to, first of all, consider all the distinct bases that someone might have for proving asylum, and also to parse, right, each of these elements. So when I'm doing an asylum case, whether it's in the asylum office or in the immigration court, I will make a chart of these elements and think about what evidence in my record shows that I can satisfy each of them, literally, right? Like a matrix on a Word document. This is helpful. It also can be, it's helpful as a starting point for writing a brief. Because if there is a message I hope to convey today, it's really that an asylum case before asylum office or immigration court is one on the strength of the record, okay? There's really, without a compelling record, there's no great legal citation or legal argument you can make to satisfy an immigration judge. The other thing, or an asylum officer, they want to see in your client's individual story, each of these elements are met. And sort of as a caveat of that, or as an outgrowth of that, my personal view is that the client's declaration, right, the written statement explaining what harm they individually suffered in the past and or why they're afraid to go back, is the most important document in the case, right? It's going to set up how their interview goes or how they testify on direct. And the adjudicator should be able to read that declaration and see how each of these elements is met, right? That is really the purpose of the asylum declaration, is to explain how your client's individual fear and their story fits within the refugee definition and the asylum definition, which are substantively the same thing. And so then the question becomes, what evidence goes, or how do I prove each of these elements? And so to game that out, what I think about is what aspects of the elements are questions of fact and what aspects of the elements are question of law. And I'm doing this for two reasons, part of which is we're going to talk about standards of review and litigation, right, a little bit later on. And when you've thought through the aspects that are questions of law versus question of fact from the ground floor, you're going to be in a better position to make arguments about the standard of review, or based on the Board of Immigration Appeals' improper application, potentially, of a standard of review later on. But it's also important to know that for anything that is a question of fact, you're not going to be able to prove it through case law, right? You have to prove it through the record. Now, your client's testimony, again, is the record. So it doesn't necessarily mean it's extrinsic evidence, but the adjudicators are going to need to be able to look at the legal materials before them and say, okay, the standard of risk is satisfied. So what are the elements of the standard of risk that are questions of fact? Well, it's pretty much all of it, because past persecution is a question of what happened, right? What is there in the past? And that's principally going to be your client's testimony that explains, I was harmed in the past, or I was threatened in the past. But the key there are the very strict credibility and corroboration requirements, right? So the Real ID Act of 2004 says that any inconsistency, whether or not it goes to the heart of your client's case, can be used to furnish an adverse credibility determination. What this means in practice is you need to be really careful about what goes into the client declaration and what is in any supporting declarations, right? Because perhaps your client's sister witnessed some event and she's here in the United States and is available to provide corroborating testimony about some instance of past persecution. You need to read that if she's going to write a declaration, and you may want her to because it's reasonably available, you need to read it very carefully to make sure there's nothing inconsistent, right? And it also brings in features from the last conversation we were having about traumatized clients. Timelines in my practice can be very difficult. Part of the reason for that is because, depending on the cultural background, the specific date of something or the specific time isn't as centered, right, in the way just sort of facts are organized. And so that can be something to document, right, literally in your asylum filing where it's something your client is struggling with, or provide an explanation for. It's also true that, in my experience, sometimes clients who've undergone, who've had severely traumatic events, especially repeatedly, tend to link those events sort of thematically, right? They'll move from one to the other because they were very similar and not necessarily in a chronological order. So working with your client to understand their story can help you be prepared to explain any type of discrepancy that's happening if there is an issue of inconsistency. Because a question of fact, right, or a credibility determination, which is a question of fact, that's treated highly deferentially by appellate courts, right? The BIA reviews it for clear error. The circuit courts deal with it on substantial evidence. So if you're in, immigration court, or to a lesser degree the asylum office, but your goal at the asylum office is to get the case approved. You need to be able to show that your client is credible. Another kind of interesting aspect of the standard of risk analysis is that predictive findings are treated as question of fact. So what would happen in the future is treated as a question of fact. So your client's testimony about what they think will happen is really important, but you're going to need to justify that, right, with the experiences of others, potentially their testimony, or with country conditions evidence that is not inconsistent with your client's story. Okay, moving on to persecution, right? Persecution involves both questions of fact and questions of law. So what are the harms your client actually did suffer, or what they fear, right? Both of those are essentially questions of fact. You want to be able to provide with concrete detail on any instances of harm. Threats can be both evidence of future harm, right? This persecutor said they were going to kill me, they were going to do something to my family. But they also can be harm in and of themselves if you are able to show that the client experienced, right, psychological distress essentially as a result of those threats. So that's where getting a perhaps psychological evaluation from an expert report can be helpful, but also, again, your client's testimony, right? And this goes to establishing rapport and client trust, because it is unlikely that your client is going to want to talk to you about all of their psychological manifestations of fear or recurrent, symptoms, things like nightmares, things like involuntary thoughts. It's unlikely they're going to want to talk with you about that the first time you meet them, right? And so having a sense of what evidence you want to eventually develop can be helpful, even if you're not asking about it in the first sort of instance. So there's also this question of state actor responsibility. If the state is the persecutor, this isn't as difficult to show, but like with Central America cases especially, we often need to show that the persecutor is someone that the state was unwilling or unable to control. And so this is one place where having country conditions evidence is critical, right? I mean, part of it is going to need to be your client's testimony. They're going to need to say why they don't think the state would protect them, but that is, this is speculative, right? Now, keeping in mind, you only have to show that there's something like a 10% chance of persecution, but we're engaging in some element of a speculative exercise. And so you want to review those country conditions very carefully to make sure they're not undercutting other elements of your claim. So for example, in the context of Afghanistan, we're seeing reports, right, in like Twitter, and because the media outlets, that the Taliban is saying, okay, well, it's going to be different for women now. Women can come back to work. They can go to school under certain circumstances, and we're not violently targeting people. And then when we talk with our clients about their communications with folks who are back in Afghanistan, that's just not the story, right? There's a level of PR that's happening here that's undercut by the facts on the ground. So it can be important to document and have an explanation why there might be evidence in the record, that undercuts unwilling or unable, right? So maybe there's a law in El Salvador that affords, protection for victims of domestic violence, but if it's not effective, right, you could use country conditions as evidence to fight back against that inference. And then nexus, why persecution is happening, is also treated, generally speaking, as a question of fact. So that's pretty difficult, right? How do you know what's in the darkest heart of the persecutor's mind when they're doing what they're doing? Sometimes you get testimony, right? Sometimes the persecutor, your client, witnessed the persecutor saying something either to your client or more publicly that shows that expressly addresses why persecution happened. But pattern and practice can be useful, and also thinking about the connotation of a word in addition to the denotation, right? And here, one thing I'm talking about is the persecutor's use of slurs, right? Because slurs often will track along nexus to a protected ground. There are slurs for members of particular religions because of political opinion, etc., and that can be helpful for showing nexus. Okay. The protected grounds themselves also are mostly questions of fact, right? And so this is why I'm kind of pushing the, think about the record, think about the record. What is the protected ground at issue, and does your client have the protected ground? So if your client says, I'm gonna be persecuted because of my religious beliefs, right, they will be asked to prove that they in fact have those religious beliefs. It's certainly a reasonable level of inquiry for the judge, or their political views. How did you manifest those? So again, that's an area that's really important for client testimony. We don't have a ton of time, so I'm not going to go super deep on particularity of social distinction, but the Acosta standard, which was the original 1987 definition. Decision that said a social group is a group of people defined by an immutable characteristic, something they cannot or should not have to change. It also says that's a question of law, so that's something an immigration judge reviews de novo, right? But since then, we've had the imposition of particularity, which means is a group defined, is there clear boundaries as to who is a member and who is not, and social distinction. Is that group viewed by broader society as like a meaningful social category? Okay, and both of these are fact-intensive tests. You need to show that in the society in question, there are clear boundaries as to who is a member and who is not, and you need to show that this group is viewed more broadly than just by the persecutor as a group that exists in society. So what I would say when you're thinking about particular social groups is a good rule of thumb to use is, does this group, exactly as delineated, exactly as I'm writing it down in my brief or in my application, does it sound like it was made up for litigation, or do you intuitively understand that this group has some meaningful existence more broadly? Because it's going to be much easier to show, and critically, it's going to be much easier to find country conditions evidence that shows that intuitive groups, much more simply defined groups, are meaningful social categories. But this can be a place where expert evidence is really important. Because one thing to think about in terms of if you are litigating a particular social group case is that matter of MEVG, which is one of the currently controlling precedents, says social group cognizability is a case-by-case analysis. Okay, it needs to be proven on every single record, which can be really frustrating, but also cuts both ways when there are terrible cognizability decisions that come down from, for example, the Attorney General or a circuit court. They say that whether a group has clear boundaries is a fact-intensive inquiry. We need to look to the culture of that country to determine if they treat there as being clear boundaries as to who is a member and who is not. So I had a case that was former witnesses of police violence in El Salvador. Frankly, tough PSG to prove, right? But we were able to use a combination of authority of circuit court decisions in an unpublished BIA case that said, well, there is a clear boundary here. Either someone spoke to the police or they didn't, and we'll treat that as the standard for particularity. And we were able to work with a El Salvador country conditions expert who talked with essentially a researcher down there who was looking into what happened to witnesses after they were informants, right, for the police, how they were socially ostracized, that they were targeted for violence. So I don't think without that expert report we would have won asylum, right? And it was again a question of, could we show on this record that social distinction was satisfied? The last point I want to make about particular social groups is there is a case called matter of WIC and HOB that is a binding board precedent. It's not clear it actually applies in affirmative decisions, but it says that the board does not have to consider a new particular social group that was not raised before the immigration judge when you make an appeal. Right, so we raise a certain amount of particular social groups. Someone makes an argument. At the board, they want to make a new argument. Well, first thing I would note, it says the board does not have to. It doesn't say they cannot, right? So for reasons that we might talk about later related to exhaustion, if you think the record supports, that there is a social group that's cognizable, that you can make out a claim for, you should still ask for it. But it also does militate towards your strategy below. before, the asylum office, before the immigration court. You need to have isolated what are my strongest bases for asylum. Maybe they are a particular social group, right? Maybe they're not. Maybe they're political opinion or religion. And those are the ones that should be the lead argument. They should be really clearly stated in the brief. Personally, I think it's okay to put in a footnote that lists alternate particular social group formulations. The reason being you're working against a shifting background, right, on litigation. We've seen this, especially with gender-based cases and gang-based cases. And you need to defend your record in case you're going to the circuit courts later on. You don't want to inadvertently waive anything. So with that, I'll transfer over to Mackenzie to actually talk about immigration court.
Thank you. I think a lot of what Zach said, I'll probably elaborate on in a different way. The perspective I'm sort of coming from is practical tips and looking at some common issues I've seen working with judges, seeing a lot of cases, practicing some of my own cases. So asylum claims in immigration court. There, okay. So Zach kind of touched on the country conditions evidence. And I think there's a tendency sometimes to think that if you just submit 1,000 pages of country conditions evidence, you are, strengthening your claim. There's so much in there. It's going to be great. There's so many possible things you can point to that it's hugely helpful. When I think in reality, sometimes that more is more approach to country conditions evidence can actually hurt you in the long run, especially if you're not actually reading through thoroughly all of your country conditions evidence. You might be undermining your claim. For example, El Salvador, if you've done any of those cases recently, the new president says, he's cracking down on gangs, they're arresting all these gang members, right? So on its face, that could hurt you if you're doing an El Salvador gang claim. However, a lot of experts and news articles, from El Salvador themselves are saying that that's actually really not the case, that the gangs are still functioning from the prisons, that people are still being released, right? So if you have some of that harmful evidence in your country conditions evidence, that's okay, but you want to make sure you have it and that you're confronting it directly in your brief because you don't want DHS to bring it up or the immigration judge to bring it up without you having first addressed it. And I think one of the best ways to highlight good country conditions evidence is to physically highlight it and to include it in the table of contents itself, to pull out some of those really strong quotes, because when the judge or the clerk for the judge is going through this big record of country conditions evidence, you just want to make it easy for them to grant. You want to put that good quote that really applies to your client, really kind of applies to a specific element of the asylum statute that says, yep, look at government unwilling, unable. They're arresting these gang members, but the gangs are still functioning in the prisons and they're still being controlled. So ultimately, it doesn't matter. So therefore, when the judge is working on the decision, written, oral, they can cite to that direct quote that you put in your table of contents that says, yeah, government unwilling or unable, right? And then expert affidavits. I think they can be extremely, extremely helpful. And I've seen a lot of remands from the Board of Immigration Appeals back to the immigration judge when the immigration judge didn't thoroughly address some of that expert evidence. So if you have an expert report that's really specific and tailored to your client that really sort of backs up your claim, that can be very helpful. One thing to be wary of is if you're using the same expert over and over and over again for the same types of claims, they start to sort of lose its punch. It's not so much the credibility of the expert, but the judge might kind of, roll their eyes a little bit and be like, oh, this again, this really generic evidence. So one thing to think about is even if you're using the same expert, how can you make each expert affidavit different for your client, so it's not just the regurgitated facts over and over again. So overall country conditions evidence, I'm not saying don't submit a lot of it, and certainly, submit more than just the State Department report, but be careful what you are submitting, make sure you're reading through it, and just make sure that the country conditions evidence itself can sort of tell the story or back up your client's story, that it tells its own story. It's not just a bunch of facts all kind of thrown together. So corroborative evidence, and by this I mean more specific things that your client could hopefully provide for you, or maybe specific news articles that kind of back up some of what your client is saying. So one thing that I saw a lot in immigration court were people talking about receiving threatening text messages. So if they receive threatening text messages, provide those threatening text messages, provide the screenshots. If they can't provide the screenshots, you need to know why they can't provide the screenshot. So that's something that you want to make sure you address with your client beforehand, because otherwise DHS or the IJ is going to ask it on the stand, and if your client isn't prepared to answer that question, that could affect their credibility. And that kind of goes with any other corroborative evidence that's maybe being directly referenced, right? If your client says that they were injured and they went to the hospital, where are the medical records? Where are the photographs of the injuries? Some of those pieces of evidence can really make or break a case. I worked on a Venezuelan political opinion case where the person had photos of being shot in the record and could actually, like show it on his body. And I mean, that was like a slam dunk case, just having that one extra thing. And I know that's sort of like a unicorn case, that you don't have that in many cases, but try to be creative. Facebook can be useful, WhatsApp, anything really. Just having one piece of corroborative evidence can really set your case apart and make it grantable. And I will say, if you are not looking for that evidence or providing it, sometimes DHS might be, and it could actually hurt your case. I've seen DHS submit photos from Instagram, from Facebook, so that's something to also be prepared for. And again, if you can't provide something, make sure you have a good explanation for it, because I've seen that used in a lot of adverse credibility decisions. So the brief itself, probably the most common issue I would see with briefs were just like a lack of clear organization, where it's not really telling the story in a way that hits all the elements. Like Zach was saying, he makes his chart where he figures out what all the elements are, boom, boom, boom. You want to make sure right from the get-go that your brief is showing why your client meets all of the elements. I think sometimes with pro bono attorneys and certain folks, they tend to focus maybe more on the harm and horrible things that happen to the client. They want to make the client really sympathetic to the judge. And I think there's an idea that if we just go really in depth of how horrible this person's experience was, like how deserving they are of asylum, that this judge is really going to feel for them and they're going to grant their case. When unfortunately the reality is that judges hear those stories all the time and they become a little bit emotionally numb. So I'm not saying don't try to make the judge sympathize with your client, but you need to back it up with law, with facts, with a roadmap that makes your claim grantable. And another big issue in briefs is not directly addressing the nexus element. I saw many briefs that never had a nexus section, and that's a really easy way to just deny an asylum claim, is say no nexus. So that's something you really want to focus on. And that kind of goes to corroborative evidence, declaration, all of those things. You want to make sure you have the evidence to back it up. And another thing that can be really helpful for nexus is case law. If you look at a lot of case law, when they're talking about the nexus, it could be like a really specific fact that they pull out, that court is pulling out to say, this is why there's nexus in this claim. It could be something that the respondent themselves said, especially in like political opinion claims, just saying like, I don't think like you should be able to tell me what to do, or something like that. Just having that one quote or that one thing from a case law and from your own case to sort of connect them together to say, this is the nexus, and not only is this the nexus based on the facts of my case, but there's also case law to back up this type of nexus, and therefore my claim is strong. I think a lot of people focus too much on the past persecution and the PSGs or the protected ground and don't really fully develop that nexus issue. And then the fact section and the kind of country conditions section in a brief, it's important to sort of lay out your story that you're trying to tell. You really want to make sure you're not just listing facts, facts from your client or facts from the country conditions evidence. So make sure you're using those sections to craft a compelling story that's hitting the elements, but also don't spend 10 pages on that, just rehashing country conditions evidence, rehashing your declaration. It's much more compelling if you can take those facts from your case and the facts from the country conditions evidence and directly connect them to the legal standards in the brief itself. So I would focus way more on that rather than huge country condition sections and huge fact sections. So I know Zach gave us a lot of really good information about particular social groups. And I do agree that if you have several viable options, that doesn't mean you shouldn't include them. I think the issue is when it sort of looks like you're grasping and you have no idea sort of what you think would even work. So you definitely want to clearly identify which group is the strongest or which part of your claim you think is going to be the strongest. I saw several frequently briefs that would just have the almost exact same particular social group with just one or two words changed. Homeless youth in El Salvador likely to be targeted by gangs, youth in El Salvador likely to become homeless, youth in El Salvador who are displaying erratic behavior likely to be targeted by police. And again, those sort of PSGs look like they're formulated just for litigation. It's really hard to prove social visibility for a lot of those types of groups. And if you're using like youth or old, young, rich, poor, it's really easy to just strike those PSGs down right away and say, well, that's not an immutable characteristic, therefore this PSG isn't cognizable. So if you can simplify it, it is much better because it's the more words you put into a PSG, the more ways there are to find it not cognizable. And I think to try to focus on a few rather than many is a much stronger litigation strategy. So again, like formulating PSGs, simple is better. Make sure you're not using any non-immutable characteristics. And in terms of nexus to the PSG, another thing you want to make sure you're doing is you're directly connecting that nexus argument to your PSGs. So it might be helpful to even include subheadings for each PSG in the nexus section to say this is why this person experienced harm and or will experience harm based on this PSG, just to make it really clear for the judge, because that's something that frequently there'd just be a PSG section and a persecution section, and how are they connected? You really want to make your case grantable, make it easy for the judge to grant. And then humanitarian asylum, withholding of removal, and Convention Against Torture Relief. I think there is a tendency to not spend a lot of time on these issues and not really fully kind of brief these arguments out and really flesh them out. So I think it's especially important to do that, especially if you know that maybe the immigration judge you're going in front of is not the most friendly. These are issues that frequently get remanded on appeal, especially CAT. So if you have a good CAT argument, make sure you are fully briefing it, and by that I mean country conditions evidence, facts directly from the record, case law, fact-to-fact comparisons if you can make that. There's BIA decisions where they granted humanitarian asylum at the BIA. CAT, again, gets remanded all the time. So especially for any sort of gang cartel violence related cases or gender cases, these can be really strong backup arguments. And then for direct and cross-examination, one sort of issue I saw a lot on direct would be to spend like 3 hours on a direct examination where you're rehashing the client's entire life, their childhood, just providing so much information that the really key information is getting lost in the details. And this can be very frustrating for immigration judges who are extremely concerned about their time. It can be really frustrating for clients, especially if your client is detained. You might be setting them up to have 3 separate merits hearings, and those are all going to be set really far apart. I mean, I saw people choose to take an order of deportation because they didn't want to continue another merits hearing because the direct examination was an entire hearing and just kept going and going and going. So, of course, you want to develop the client's story and, develop sympathy for the client, but you also need to be strategic with your direct examination, that it's not just so broad and sort of lengthy and confusing. And you need to make sure you're asking questions that are going to every element of the claim. Again, the nexus, people frequently would not ask questions that would directly get at the nexus. And you also want to make sure your client can testify in a clear way about nexus. So if the judge or DHS says why, Why did this person target you? Why do you fear in the future you'd be targeted? And the response is something like, well, that's just what happens in, my country, or I just knew that's why they were doing it. That's, again, not a very good answer. It's not specific enough to really show nexus. So that's something you want to make sure you talk with your client beforehand to develop. And the government unwilling, unable, sort of police questions came up a lot. So if the person had something happen to them and they didn't go to the police, that's something you really want to ask, well, why didn't you go to the police? Make sure there is a reasonable answer, because frequently the answer would be, the police don't help. The police don't do anything. The police are, they work with the gangs, they're in on it, right? And while all of that may be true, it's very vague, it's very general. And you want to be careful if your client is giving this very vague testimony, because some judges will find that non-responsive and adverse cred that person, essentially. So just make sure you're preparing your client to testify clearly on some of these issues, because these are things that they could really be attacked by DHS and the immigration judge on essentially cross-examination. And as far as cross for the practitioner, I think it's really important to address any inconsistencies. One of the most frustrating things is when a client might contradict themselves, might be inconsistent with some of their written evidence, and ultimately that doesn't have to be fatal to your case if your client can explain it. So make sure you are giving the client a chance to explain that on the record, because the immigration judge might not. And especially thinking about the appellate record, you want to have that explanation in the transcripts. So overall, just be strategic. And again, think about the elements that you are trying to develop for your claim. So credibility, this was a huge issue at the court I was at. I might not be as big of an issue depending on where you practice, but there were a lot of adverse credibility decisions I saw. So one thing that came up frequently were practitioners going so specific on their declarations and affidavits, and I know that's really a fine line to walk, because you don't want to be so general that you're not actually proving your claim. But for example, using extremely specific dates, if your client can't recall an exact date, I would not put that in my declaration, because I did see people were found not credible because 1 or 2 days were off when they were in their testimony. So just think about your client. You've talked to them, you've interviewed them. So some clients are better at testifying than others. If you know your client has a problem with not answering questions directly or being vague, keep that in mind when you're writing the declaration of what you're submitting. And again, you want to address any inconsistencies, and a huge thing to look at is the credible fear interview, or even just the I-213, that kind of summary. We had a case come up recently where the person said they had no fear of future persecution or torture in their I-213. And it was a case that had been going on for like a really, really long time, so it just wasn't caught. And the immigration judge used it to find the person not credible, but the immigration judge never asked the client about this on the stand. They never talked about it on the stand, period. So looking back, it would have been great if we knew that that was in the I-213 to ask the client, well, why did you say you have no fear of future persecution or torture? Because there's many reasonable explanations that could have avoided that whole situation altogether. And especially with credible fear interviews, recounting like sequential events and using dates and things like that, names, you just really want to make sure that it's lining up with your declaration and hopefully with your client's testimony. And then this might not be as applicable to people who aren't practicing at a border court, but the journey to the US and the missing passport. This is kind of like a red flag that would come up if the judge wanted to find somebody not credible. Where is your passport? How did you get to the US? That journey discussion, it doesn't go to the heart of the claim, right? It doesn't go to any of the elements, but it can still be used to find somebody not credible. Many people use smugglers to get into the US. That's just a fact, and that in and of itself isn't gonna make somebody not eligible for asylum. But if the client doesn't want to tell the judge that, and the smuggler has the passport, and that's why the passport is not at the court, not with DHS, it's very important that the client tell the judge that. One of the things that came up a lot, the court I worked at, people were asked, well, where is your passport? And the most common answer was, I lost it in the jungle in Panama. That, I think it's like the Dorian, right? Jungle? Yeah, Dorian. That came up all the time. And it seems like a small thing, but that's just another thing to add to that adverse credibility section. So I think it goes to making sure you talk to your client about their whole journey, their whole story, making sure that they can testify credibly, and letting them know that it's okay if you use a smuggler. That doesn't mean you're not eligible for asylum. You can be honest about that, right? There's specific case law, specific rules about the way people are fleeing their countries. They might have to do certain things that we frown upon, right, in the US, but that's okay because that's part of being an asylum seeker. So I think the big thing is just to make sure you address it. And then if you know your client's having any kind of mental health issues or has any sort of physical impairments, like a traumatic brain injury, that are going to affect their testimony, you want to come prepared to explain to the judge why your client maybe is inconsistent, why their testimony is vague, why they're non-responsive, right? Because if you're not telling the judge, well, my client has PTSD from the decades of domestic violence she suffered, so she's having, huge issues telling her story chronologically. She has forgotten key details because of her mental health issues. So this is something that can be extremely, extremely helpful if you know your client is probably not going to testify well. A matter of JRRA is a great case for this issue. You don't have to have any, mental incompetency. You don't have to rise to the level of the matter of MAM, but it basically allows people to implement safeguards. The judge should implement safeguards if your client is having physical or mental health issues, right? So if you know your client is just not going to do well on the stand, you can ask the judge to rely on the declaration. If you know your client is going to break down and have a really hard time or lose his focus, you can request more breaks. If you know that your client is going to give really vague answers, you can ask to cross your client, basically, right? Ask leading questions on your direct. So I feel like this is an underutilized approach and can be very, very helpful for many clients, because essentially most people who are seeking asylum and have experienced past persecution are extremely likely to have PTSD, anxiety, depression, all sorts of mental health issues. A huge thing you can do for your client is to get them evaluated and to have those diagnoses so you can explain to the judge why their testimony isn't up to snuff. Unfortunately, I think a lot of immigration judges are lacking in patience. They have a lot of burdens on them, and they get frustrated when people don't testify and answer the questions that they're asking. So you don't want to frustrate the immigration judge so much that they just want to look for a reason to deny your client. If you can provide this evidence, I think that will help that issue. All right, I think that's all for me. Pass it on to Nadia.
Thank you so much. All right, what I'll be talking about now is basically once the asylum case makes its way through the immigration court and then the BIA, unfortunately, if you are in a position where you have to go to the circuit courts, it's because your client has lost. And so I'm going to be talking about some of the ways that you can use experiences in immigration court to then strengthen your appeals and vice versa. My colleagues Zach and Mackenzie talked about the obvious importance of ensuring that you have a very, very strong factual record and sound legal analysis for all of the elements that come into play in these cases. But then what I'm going to focus on is how to use an understanding of appellate practice to make sure that you have that strong factual record, sound legal analysis, and vice versa, how litigating in immigration court can then strengthen your appellate practice as well. And so, one of the things that I tell my students, we normally practice in federal courts outside of the agency, but Sometimes we also have cases that might get remanded back to the immigration court or back to the BIA. And I always tell students, even though we are practicing now before the immigration court or the BIA, you have to approach what you're doing at that level as if you were talking to the appellate court. So always considering, how am I briefing the case? How am I setting that factual record at the agency level with an eye toward a potential appeal? Hopefully you won't get there, but one of the ways that maybe you won't get there is by having that understanding of how appellate practice should inform immigration court work or BIA work. And, we can talk about that for hours, and I do in fact talk about that for hours in my clinical seminar, but what I'm gonna focus on today are three primary issues, again, of that appellate practice and how it should inform immigration court and BIA work. And three of the important aspects that I'm gonna talk about is, it sounds kind of elementary, but framing your issues once you are in appeal, how to talk about the error that you believe the BIA committed or the immigration judge committed to put your client in the best possible way to then succeed at the appellate level. Another one is how to exhaust issues and arguments, and not just how to, but the importance of this notion of exhaustion, because you can have, a winning argument, but if you do not, quote unquote, exhaust it or present it to the agency first, your client could just be completely barred from having a judge actually review or take a look at that issue. So it's incredibly important. And then I'll briefly talk on this other distinct but related concept of waiver of particular arguments. Okay, so the issue of framing, how once we actually have a loss at the BIA, I need to go to a circuit court, how are we going to frame a particular error that happened in an asylum case, again, in a way to position your client to have the best possible outcome? And, the thing that I want to focus on there is that it really needs to be informed by some of the standards of review that Zach mentioned early on. Not errors are created equal at the circuit court level. And this is really just mandated in part by how Congress provided in what we call the judicial review statute, how Congress said, once you get to the point of having your case reviewed at the judicial level in circuit courts, how those circuit courts need basically to review the agency level. And one of the things that we could talk about for hours is this kind of relationship between agencies and courts, but the thing to keep in mind is that there's just a lot of deference at the judicial level for what the agency does. So there's this notion that immigration judges are the experts, the Board of Immigration Appeals are the experts. So once you get to the circuit court level and then the Supreme Court, the judges should be really just giving a lot of deference to, quote unquote, the experts who are seeing, as Mackenzie said, day in and day out, these cases, and should reverse lightly, is quite frankly what the view is. So three main standards of review, two of which I'll talk more in depth about. The first is how courts will review, quote unquote, just legal issues. And that's the strongest position to be in as a litigant in the federal courts, where you are presenting a legal error, because for the most part, circuit courts will review that de novo. And anybody who speaks Latin here, anew, basically from scratch. There is no deference that's given to how the agency below actually decided or what it had to say about that particular issue. And so the circuit court will review it as if it were the court of first instance, so to speak. And so some of the common issues that might be subject to that de novo standard of review are whether a conviction actually should trigger a removal ground. Is a particular conviction actually an aggravated felony offense is one of the most common ones that we litigate. Or is a criminal conviction actually categorically a crime involving moral turpitude? And so that puts you again in a position the strongest position before the circuit court, but it's not just limited to criminal convictions. I'll talk about, how you might want to litigate nexus issues when you get to appeal. Questions of fact are kind of scary in my practice because if you're arguing at the circuit court level about a factual dispute, it's going to be really incredibly difficult, not impossible, but just very difficult to get a circuit court to say, yeah, the agency, the BIA, the immigration court committed errors of fact. And again, there's that overall notion of deference to the agency, and in particular, deference to the individual who's sitting, behind the bench in the first instance, looking at demeanor, credibility, witnesses. And so the courts really tend to, by statute, give a lot of deference, or must give a lot of deference to those determinations. And so for questions of fact that are being appealed, it's a standard that's referred to as the substantial evidence standard. And that standard means that a court reviewing the issue has to uphold it, basically say you are correct, unless the evidence is so compelling that no reasonable fact finder could have found the way that the agency did. So in order for the courts to actually reverse a factual issue, they have to say that the fact finder was unreasonable. And so as you can imagine, that's a pretty high bar to meet. I'm not going to talk about the abuse of discretion standard, but it's another common standard of review that circuit courts use to, for example, review denials of motion to reopen. And so where does that put us? Like, what is the practical tip at that point, based on these standards of review? And what I can say is that they should inform how you're litigating these issues. So for example, Zach mentioned nexus, right? That's mostly considered an issue of fact. And so based on these standards of review, it's very difficult to argue to the circuit court, again, not impossible, you see the wins and they're great, to say that there was the agency committed a factual error in finding that there was no nexus. But if you can think about your case and think about the issue as from the legal perspective of saying the agency actually misapplied a particular legal standard in evaluating the nexus element, then that can put you in a much stronger position to then get even a remand for the agency to consider that issue anew. And so even though, I'm talking about what happens at the circuit courts, that starts to inform how you write your brief on nexus, right? Making sure that you're actually setting out the correct legal standards for the agency to apply, so that then you might be able to challenge the agency's actual application of those standards versus, arguing about the facts. Other examples, basically go to that same thing, which is you're in a much stronger position if you're able to say the BIA committed legal error by misapplying, its own regulations, or the agency committed legal error in not finding the facts surrounding persecution, like the what, when, what happened, but in actually saying those facts, as established, did not rise to the level of persecution, which should be a question of law. Whether established facts actually rise to the level of persecution should be a question of law that's reviewed de novo. And I say should because that's actually a question that's being thought about in the circuit courts. My clinic has a cert petition at the Supreme Court right now actually challenging the Eighth Circuit's rule that whether or not facts rise to the level of persecution is not a legal question, but a factual question itself. And you can imagine why are we arguing about that? That's so important because, again, if it's a question of law, as we claim that it is, then circuit courts give a lot less deference, or actually no deference, to the agency. But if it's ultimately a question of fact, then we're subject to that very deferential standard of review for substantial evidence. Okay, another thing I'll talk about is this notion of exhaustion. And so exhaustion for, administrative law geeks, it's really founded on this notion that in order for the judicial system to review an issue, the agency must have a chance to actually pass on it in the first instance. So essentially, judges should not just sweep in and take over, but before they can review any error, the agency itself, in this case, the BIA, should have the opportunity to pass on it in the first instance and then to correct its own errors. If the immigration judge committed an error, the BIA should have the responsibility and opportunity to address it in the first instance before that's actually litigated at the circuit court level. And that is, again, I talk about Congress and the statute, but that is codified in the judicial review statute that governs how cases are presented to the circuit courts. And so what that says, and I have the statutory language there because that's also subject to litigation at the Supreme Court right now, and that's something that I'll talk about briefly. But it says a court may review a final order of removal only if the non-citizen has exhausted all administrative remedies available as of right. And there's a case right now at the Supreme Court that was granted cert that is going to be reviewed, and we're going to have guidance on that soon, called Santos Zacarias. And that case is, the questions presented in that case are whether that statute, 1252 D1, 8 U.S.C. 1252 D1, two things about it, whether it's jurisdictional and what it means to exhaust administrative remedies available as of right. And what I mean when I say whether it's jurisdictional, it means if a non-citizen has not exhausted, and I'll talk about like practically what that actually means, if a non-citizen has not exhausted, does that mean that the circuit courts just cannot review the issue at all? It means you are barred, the courthouse doors are closed for you. That's what it means to have requirement be jurisdictional, or whether there's some exceptions, and essentially the courts can say, okay, you didn't exhaust, but I'm still able to review your claim anyway. So it's quite a significant issue whether or not this requirement is jurisdictional. And then the other one is like, what does it mean to exhaust administrative remedies available as of right? And I'll talk about Santos Zacarias in a little bit. But again, in practice, what does it mean to require the non-citizen to exhaust? And the Eighth Circuit, unfortunately, is one of the most hostile circuits to litigate immigration cases. Generally, the Eighth Circuit's where we sit. Asylum cases included in that. But what that means is for you to have been considered, for a non-citizen to be considered, have exhausted a remedy, it means that they have to have presented, and I quote here, a specific legal theory to the board. And what that means is if you want to fight about something at the circuit court level, your brief better have included the specific legal theory that you're arguing about at the Eighth Circuit to the board. Other circuits are much friendlier to non-citizens, where they might consider something exhausted if one of your arguments at the board level can be, reasonably construed to encompass the argument that now you're presenting to the circuit court. Kind of like if you have an overall umbrella theory at the board level, and then you want to present a specific argument at the circuit court, if your argument is, within that broad umbrella, then you will have, you can satisfy the exhaustion requirement. But here at the Eighth Circuit, it's just very important to keep in mind that you have to have presented the specific legal theory to the board. So something to watch out for right now, and again, because this issue is being litigated actively at the Supreme Court, is this requirement that you might have to exhaust through a motion to reconsider. And so what that means is you're at the immigration court, you lost, you're on direct appeal to the Board of Immigration Appeals, you lost. Generally, you would think after I lose at the board, then I'm going to go to the circuit court to pursue, continue pursuing my client's rights through further appeal. Well, right now, there's a circuit split. A circuit split meaning some circuits are saying one thing, other circuits are saying another thing, and that's why the Supreme Court's now intervening. Whether, before you get to go to a circuit court to continue pursuing your appeal, whether you have to file a motion to reconsider at the Board of Immigration Appeals to basically say, Board of Immigration Appeals, your decision was wrong, and you should reconsider it. And then after the board, basically that's founded on this notion, again, that the agency should have, first pass at correcting its own errors. And then after, you actually go to the board on that motion to reconsider, whether then you can seek judicial review. And so in a case that actually came out of our clinic, the Eighth Circuit said, yes, to meet that statutory requirement that I had up there for exhaustion, you have to file a motion to reconsider first. Otherwise, the courthouse door again will be closed to you, and you won't have judicial review of whatever arguments you are raising. And so this is, probably the biggest takeaway that I want folks to have from my part of the presentation is I had to very, very carefully evaluate whether or not to file a motion to reconsider from an adverse Board of Immigration BIA decision, until at least we know one way or another from the Supreme Court whether the Eighth Circuit got it right. And some circuits say that a motion to reconsider is only required if the error is new. So it's not, an error that arose in the immigration court and then the BIA, did not correct it. But basically that motions to reconsider are only required if the error is in the BIA decision itself for the first time. What that means, quite frankly, I don't know. So if somebody can, tell me how to evaluate whether an error is new in the Board of Immigration Appeals decision, please come talk to me. And that's one of the reasons why this rule just makes no sense, aside from the fact that it's not actually derived from the statute. But, that aside, as a practical matter, is like, what's a new error? When do I file a motion to reconsider? Should I file a motion to reconsider on everything? Otherwise, my client will not have access to judicial review if I don't file a motion to reconsider. So again, I'm not here to give legal advice, but we are advising our clients file motions to reconsider, because otherwise you might actually be barred from pursuing your rights at the circuit courts. So, there's a lot of folks litigating this issue. If you're a practitioner who has questions about this, make sure you reach out to folks engaged in some of this litigation to make sure that your client doesn't lose his or her rights. So if you want to tune in for oral argument, it's January 17th. Oops. Okay, might have been on that slide before. But the last thing I'll briefly touch on is this related notion of waiver and waiving particular issues. So you frame them, to give your client the highest chances of success. You know how to frame it as maybe a legal issue versus quibbling about the facts. You exhausted it because you presented it to the BIA. If it was an IJ error, if it was this quote unquote new BIA error, you filed your motion to reconsider. Then, what is another potential pitfall that you have to avoid? And that's to actually waive the argument at the circuit court. And the most common way that arises is that you just don't develop your argument sufficiently. And again, you might be surprised that the Eighth Circuit is one of the most hostile circuits on this issue, and really, quite frankly, on all others related to immigration. But the Eighth Circuit, for example, says that even if you raise an issue in the appeal, if you don't provide meaningful development of your argument, then the Eighth Circuit can say, you're actually waiving this argument, you're not developing it. And so, sometimes I think I didn't mention this early on, but before I was at the Binger Center as a faculty member, I clerked for the judiciary, so I worked for 2 judges, one at the circuit court level. And, it is a little bit, it was an interesting learning experience for me that sometimes, then this is not just an immigration litigation, but sometimes practitioners, I wonder if they've gotten this, they can get the sense that, an argument is so obvious, or like just by citing to a particular case that clearly supports your position, that then the court is going to take it upon itself to develop your argument for you. And that unfortunately is not the case. Courts are not in the position of being advocates. They are supposed to, again, in theory, adjudicate disputes and arguments based on how they're presented by the parties. It's an adversarial system that does rely on argument development by both sides. So again, make sure that you sufficiently develop your arguments. And that also applies at the Board of Immigration Appeals. Like if, you presented your brief, the evidence, you have to articulate why it is that the immigration judge actually erred in a sufficient way, not only for the BIA to consider it, but then again, at the circuit court, so that it's sufficiently exhausted. Like, it's like, I told the BIA about this error, now, circuit court, you have to consider it, and also that it's not inadvertently deemed waived. And I think that closes out our presentation, right?
Yeah, great. Well, thank you so much for providing us with so much to think about. And if I'm seeing the queue correctly, it looks like we might have a number of questions. So I think I'm just going to open it up to Q&A.
Yeah, I will pepper you with the questions from our folks on the Zoom, and then we'll take some questions from here in the room. So there's 4 questions. I'll give you all of them. You guys can think about and decide who wants to respond. And they're from various parts of the presentation. So one was, can you give examples on Ukrainians feeling the war? There was another question, what non-state actors are most likely to be recognized and what non-state actors are least likely to be recognized as persecutors for justifying relief? I'm getting a lot of asylum cases recently where people are telling me they lost their passport in the Panama jungle. Are you saying this is not credible? I'm struggling with these cases. And then someone else had put in the chat an article from the New York Times about that had some photos and talking about family separation there, so I can share that in the chat with others. And then the last question, in regard to bars for asylum, have you seen any developments or new cases for cases dealing with de minimis support to groups, for example, paying under duress to guerrilla?
I think I can talk about the 4th one and maybe the 1st one.
I don't know about the second one, then. Do you?
Okay, I can also share. Okay, thank you. Those are all really great questions. First thing I want to flag, I'm going to start with the last one first because it has the most direct answer, which is there any development on case law with regards to de minimis support for, this is what we call the material support bar, the material support for terrorism. And just as background, that might sound really, really bad, but the statute is quite expansive as to what it defines as terrorism. Terrorism can mean any group of more than one person that uses violence against a person or a thing or property. Literally, right? If you go to the INA, that's what it says. So this is a big looming issue in a lot of cases, and I think perhaps this person has an Afghan case because, we have situations where, for example, the Taliban was robbing people on the highway, right, and putting a gun to them and saying, to get through this road, you need to give us some money. And then if the person gave money, what do you do? Because the case law on this is determined by a board case called Matter of ACM, which is a terrible case. It's one of the least reasonable decisions I've ever seen. It was a woman who was enslaved by a group, a group they deemed a terrorist, and she was like cooking for them, and they said, well, that's material support because you were cooking for them. So how do you deal with this? Well, there's a difference between an exception and an exemption, and there are discretionary exemptions by the Department of Homeland Security dealing with de minimis support for terrorism under these situations or certain limited material support. And the development in the exemptions have been, this happened in the last year. Previously, Previously, these exemptions only existed for support for groups below a certain threshold, and the administration has changed that, I think largely in response to the situation Afghans are in. So if you go to the USCIS website and you search for, material support or TRIG exemptions, you will find explanation on certain limited material support under duress, Afghan allies, a whole list of other ones. One really important process point on this, if you're before USCIS, it's kind of simple. You just make your argument, and the asylum officer, or if it's on an adjustment case, the USCIS officer just considers it automatically, right? There's no special application. You don't have to brief it separately. It should just be there. But you want to make sure you have facts to furnish an exemption if you need one. In immigration court, it's a really different story. The position ICE, because it's up to ICE, and the position ICE has taken is they will not grant this discretionary exemption unless every other issue in the case has been resolved. So if you are in this situation and ICE is putting it into issue, and that's the basis for the claim, you need to get the judge to make findings on every other part of the case as well, or ICE won't even consider it. So, I'm not sure all immigration judges even know that, but if you find yourself in that situation, that's really important. And then to the first one, I think this was a question about, basically what are the odds for asylum for a Ukrainian dealing with the war. It depends because it's going to depend on the person's individual situation. Do they have past persecution on account of a protected ground? That's really important. If you can show that, it shifts the burden to DHS to prove that persecution is unlikely, right? So that's the first piece. Is someone have persecution on account of a protected ground that you can show? There's an issue, if they don't, there might be an issue showing well-founded fear, because one of the situations, or one of the factors for that is internal relocation a possibility, right? Is there another part of Ukraine someone who could go to where they would be safe from persecution? Here, I'm assuming, the person is saying they would be persecuted by Russia or a Russia-sponsored agent, but that's not necessarily true, right? Maybe they have some individualized situation where they fear a different persecutor who's all throughout the country. The last point I would raise on this is what we call humanitarian asylum actually really covers two things, okay? Humanitarian asylum is how you can qualify for asylum where you only have past persecution. And you don't have a well-founded fear. And the argument most people make is, my past persecution is so severe that you just can't send me back to the country, right? So, the most obvious example of this would be like a Jew who, going back to contemporary Germany, who was a Holocaust survivor, right? You have a really strong argument for you can't send me back there. It's too bad, right? What happened in the past. So even if I don't have a current risk of persecution, you can't send me back. But there's actually another ground or another way in the regulations where someone faces a reasonable possibility of so if you have past persecution on account of a protected ground, under the regulations in a case, I think it's called matter of LS, it says you have past persecution on account of protected ground, if you face a reasonable possibility of other serious harm, that can be basis for asylum. I think that's going to be a really important argument for people who are asylum applicants from Ukraine to make. Keep in mind, you still need to show past persecution on account of a protected ground, but if you can, I think the war would fall under the scope of the factors for other serious harm. So that's just a more kind of new argument to consider. The next question was what non-state actors are most likely. There's no list. It's going to be what you can show in country conditions evidence or not, right? And that's where having detailed client testimony comes through, and then having country conditions experts, right? If it's not a situation where the persecutor is well known, well publicized, that can be an area where country conditions experts become really important.
Yeah, and I will say on the non-state actor thing, we've run into issues where some immigration judges don't seem to understand that AB 1 has been overturned. So those sort of personal relationship abuser non-state actor, and then possibly also just gangs or cartels non-state actor. Those are always going to be typically the hardest. But ARCG is good law, AB3 is good law. You still have a chance. Just depends on the facts of your case. And I will say to the Panama passport issue, it's possible a client could lose a passport in Panama, but there is the problem is that if so many people are telling an immigration judge the same thing, then it immediately becomes a red flag and you lose credibility. So most likely the person has used a smuggler to come to the US who's probably holding their passport and they don't want to admit that. I will say you have to be really careful because the agency does keep track of if too many people are telling them the same thing, and that is a way you can deny asylum claims. Like, I worked on many denials for folks from northern India, Punjab region, saying they were being persecuted because they were Sikhs and they were being persecuted by the Congress Party, which really doesn't flush with the current country conditions evidence. And we were able to deny most of those cases just because they were essentially repeating the same story over and over again. So because this passport Panama thing has been repeated over and over and over again, even if it is true, it seems unlikely, it's just kind of a red flag and makes the judge go, ugh, not credible.
I think we have time for a couple questions in the audience. Anybody?
I just have a quick question regarding some of the gender-based and I guess probably gang-based claims as well. Sometimes they go hand in hand. When you're creating a cognizable PSG or arguing for a cognizable PSG based on gender, do you guys have any tips on, I guess, what you've seen makes for kind of a successful PSG when we're dealing with that?
I'm a big advocate for gender per se PSGs. There's no reason why they shouldn't work. There was a really good case out of, I think, the Second Circuit called De Paniagua v. Barr. And essentially the judge, of course, they didn't actually find that that PSG was cognizable, but she actually provides reasoning based on social distinction, based on particularity and immutability, why such a PSG could be cognizable. And in the Eighth Circuit, there have been gender per se PSGs. But of course, the immigration judges here, specifically a couple, I know will deny on that. So of course, that's not the only one you should use, but I strongly advocate for using that because if you look at, matter of Acosta, and if you're applying, a jusum generis to the asylum statute, there's no reason why gender couldn't be a valid asylum ground. But I will say, I've noticed in case law, besides like ARCG kind of formulations, the women viewed as property it seems like more recently has been struck down more often. That doesn't mean not to use it. It just seems like it's not quite as strong. But when AB1 was good law, there was a lot of movement in the political opinion. I think it's Hernandez Chacon v. Barr is a really good case about essentially if you're being targeted because of your gender and you kind of assert that you're being targeted because of your gender and you don't agree with that, it's a political opinion or imputed political opinion. So I think that's something people should consider for gender claims is political opinion.
I would echo all of that. Totally agree. Topena Paniagua was a case that I worked on an amicus brief for in the First Circuit, and I will say after it came down, Boston Immigration Court and Asylum Office just viewed it as cognizable. And there's a lot of immigration judge decisions across the country that you can find and submit for it. On viewed as property, there's a version of that that's in the matter of LR and the matter of RA briefs that the Department of Homeland Security submitted. And so if you go on the CGRS website, you can grab those, and I've submitted those into the record because I'm like, well, DHS, you're contesting this now, but this comes from you, right? And part of the reason I'm doing that is because it's building a record for if this case is gonna go up to the circuit court and they see, why is this law so confusing? It's because of the Department of Justice, the Department of Homeland Security, kind of going back and forth and coming up with standards that frankly don't make sense in this area. But last point, keep in mind, women as the social group, right, makes intuitive sense. It's about keeping the elements distinct in your head. There's a different question of whether women is a cognizable social group from whether an individual woman experienced past persecution or has a well-founded fear on account of gender. The issue is nexus, and then nexus, keep in mind, gender has to be at least one central reason for persecution, not the only reason. So making those arguments stating them very clearly, I think is really important in DV cases.
Great. Well, please join me in thanking our panel. That was excellent. Food for thought.